Okay. Oh, good afternoon, everyone. This is Curt and
Brad Pinsky.
all right. And here we are for another edition of Fire Law Roundup. I am coming to you from Park City, Utah, where we've got a discipline class.
Okay.
Good afternoon.
Oh, here we
this
go.
Is Curt and
This
is the problem.
Right. And here we
Let's
are.
start over.
Of Fire Law Roundup. I am coming to you from Park City, Utah. Where we've got a discipline
And
class.
obviously, I'm not in my regular
good
studio,
afternoon.
so
This is the problem.
One more time.
okay, finally got it. Again, my normal studio, I have my office, we have this kind of stuff worked out ahead of time, but that's the problem. If I don't click that one particular button, and I usually have 3 monitors, and so I apologize. And I think I'm a little jet lag, number one, and we're up at I think it's 6,800 feet. So you may see me a little bit out of breath. It takes a day or so to get acclimated up here. But Brad, go ahead, take us through past week's crazy week here, but take it.
And I'm going to tell you, usually I've got a pretty good handle on the cases we discuss, and there are some here. Fortunately, they're shorter ones that I just don't understand. But let's start with the big bang, the shot heard around New York. And this is the lawsuit by some very high-ranking FDNY chiefs against the new FDNY commissioner. They have now sued, as viewers may remember. We've already talked about this. And they claim that the commissioner was removing them. There were, I forgot what they said, like 11 out of 18 who could run incident command, and she removed like 11 of them, and they've been ignoring their advice. And now what they allege is that this is all based on ageism, that this is
Brad, I'm not sure if I locked up or you locked up. Oh, and we just lost Brad. So, well, hopefully he's going to rejoin us, and we'll keep going. But there you are.
I didn't even know I was gone.
Yeah, you just locked up and you were gone. So,
excellent.
I do want to just one thing. What the whole 11 out of 18. I think what that was is. They have 11 out of 18 that are qualified or experienced at dealing with third alarm or greater incidents. So certainly they have hundreds of people who are, more than qualified, for first and second alarm. And there's a level of complexity, I think, that happens in New York when they get to those greater alarms, because you're talking about, 100 to 200, 300 or more firefighters at the scene. And you got a lot of logistics that, not that they can't command the operations, but it's all the logistics and communication and everything else when you have that many people.
Right. So here we have, and I'm not sure what we call it, but they're claiming ageism. They're claiming that because they're 60 or over, that she's trying to get them out and get them replaced with lower pay. And experience matters, as we know in the fire service. So it's interesting. Obviously, we can't comment. We don't know what the commissioner's thinking, right? It doesn't look good. It's hard to allege. I'm going to say this. So look, let's go back to McDonnell Douglas, right? So everybody knows they have made out a case. The fire chiefs have made a case that, hey, we're all over a certain age. The same thing is happening to us. We're all being disciplined or penalized, or benefits cut, or denied leave, or all these things. We're being humiliated. Basically, the commissioner's coming after us. And the only reason they can come up with 11 of them or so, right? But what these senior chiefs have come up with saying it's got to be ageism. They're trying to get us replaced with cheaper people. And I got to tell you, that is going to be a tough defense for the FDNY, because what can you possibly have on this many chiefs, whether it's 4, whether it's more? What do you possibly have on this many chiefs where you could say we have a reason to be doing all these things to all of them? The only thing they have in common, presumably, is being senior and being over 60 or so. So, it's so hard to talk about this because in my mind, I'm thinking, listen, seniority and age go together. You don't get experience while you're young. You get experience when you get older. And in the fire service, it's just axiomatic that we are going to have senior people with significant experience who are older. So it's incomprehensible to me to think that anybody would say we want to get rid of that experience just to lower the payroll, which in truth will have no real impact.
I don't think it's got anything to do with payroll. That's a private industry concern. I think what you have here is that she wants to take the organization in a more inclusive direction, in a certain social and philosophical direction that doesn't align with the culture and traditions of FDNY. And when the chiefs point this out, they're finding themselves at odds with her, and she's accusing them of disloyalty or whatever. There's a few terms in there you can read, in the complaint, misogyny and some other things. But she's basically interpreting them saying, look, we can't do it, and this is why, as being evidence that they're not willing to be on her team, they're not willing to support her vision or whatever. And they're actually calling into question her vision and whether or not she's got the experience and sort of institutional knowledge to be making those sort of policy decisions without any input from the vast experience level of those chiefs. So,
and the past commissioner came up through the ranks, served as the chief of FDNY, if I'm correct, right?
And that was one of the points. Most of the chiefs, most of the commissioners came through the ranks, and those that didn't heavily leaned on those who came through the ranks. And she's kind of taken a whole new approach. And if she had run a business or she had successfully, done anything outside of the political arena, you would say, well, she's got the credentials to be running a business. Now, maybe it's not a fire department, but, maybe she could be running Coca-Cola, CEO of Coca-Cola, or, you know what I'm saying? But she doesn't have that kind of track record.
And more than that, last time one of their complaints was that like the SCBA committee, they have to buy like $50 million or some astronomical amount of new SCBA. And the chiefs were on the committee, and she said, we're not even on the committee anymore. She's making the decision with non-firefighters. I'm like, how do you do that? If you don't wear it, if you've never worn it, how do you make the decision yourself or get rid of the people who do? So I'm blown away. It's hard to come up with anything. And look, disloyalty, she could have a very simple answer. It has nothing to do with their age. It's just that the senior people, having nothing to do with their age, are just disloyal to me. And at the top, I'm not going to tolerate disloyalty. So I'm cutting the head off the snake. She could do that. All right. And that's not ageism.
She's got to be able to prove it.
As do they, right? But she's better come up with something. But they have been attacking her. They have been disloyal to her because they're very outspoken against her. I don't know what they
were prior to, I'm not sure exactly when. That's going to be all of the proof, right? That is going to have to come out in the litigation. But if they were disloyal, and she can document it and say, well, here's this example, here's this example, here's this example. But again, I think if she had come through the ranks and she had the credentials to make independent decisions, that she didn't need any subject matter expertise to assist her with, I think she'd be in a better position to make those kind of disloyalty arguments. But you can't, like, it's just like you and I had spoken before about this. Like, I've never been in the military. Okay, I have got no business being put in charge of an aircraft carrier. That would be crazy.
Right.
And working as a clerk or an administrator for the Navy for a couple of years doesn't qualify me to run an aircraft carrier. It's pretty much as simple as that, And so that is a concern. And you aptly point out, though, that qualifications in a position like this really are the function of the mayor to decide. Like it or lump it, but if the mayor feels she's qualified, that's you can fix it at the election booth.
Well, not Manhattan, you can't, but maybe if the FDNY comes out against them. But I I sympathize with the fire chiefs because not that it's a legal issue, but I sympathize with them saying, how are you, though? I mean, these people are so decorated, so experienced, and to cast them aside and then say, well, I'm not going to listen to you and you have to support me for that, right? You can't be disloyal to me. You have to support my decisions when they're not based on experience. I got a hard problem with that. But that doesn't mean that it's ageism, right? She may be wrong morally for casting them aside and even, giving them a hard time for going after her. But nonetheless, that doesn't mean that the lawsuit wins the day. So.
Well, we'll see. I mean, we could talk this one to death, and maybe we can get somebody. Probably will need a retired FDNY person who has intimate knowledge of all of the factual details.
Well, I'm not going to name names, but two of the most senior people who just left, I'm sure would be more than happy to come on our show if you want me to reach out and ask them to come on next week.
It might not be a bad idea. Because we're speculating. Let's face it, we're speculating.
Right.
And,
let me see if they want to talk about it. Obviously I won't drop names, but once you see them, everyone will be like, oh, well, that's obviously what you're talking about. But, I don't know what the loyalty of prior people are and if they want to get involved or not, but let me see if they'd come and have some, it would be a really exciting, interesting thought. Let's do that. Yeah. I'm going to reach out to them tomorrow morning and see if they want to come on next week.
Sounds good.
Okay, so now let's keep going down the shaft here. Whereas the chiefs may be getting the shaft, now let's go to the elevator shaft. I don't truly understand this case, and it doesn't justify a lot of discussion other than just to say what's happening. A woman is suing a Delaware fire department and some elevator maintenance people and others because she stepped into the elevator, it wasn't level, and she trips or hurts herself. It's a little tough to figure out exactly what happened, but she fell because the elevator floor is not level. I'm not sure why she's suing the department other than I'm guessing they were there and they brought the elevator up or down and left it unlevel, or do you understand this anymore?
Yeah, I think I do, but I got to speculate. Okay, so I'm drawing on my experience, but very typically when we have an elevator emergency, and this is in a Holiday Inn Express, which I stayed in one last night. As a matter of fact, it's Salt Lake City. But they typically will have two elevators side by side. And so when elevator one is stuck, there's a problem with elevator one, very often we'll shut down both elevators, open the hoistway door on elevator two to access the ability to open the doors on elevator one. Okay, so you've opened the hoistway door. And I actually got a question on LinkedIn about this, under what set of circumstances could the fire department be liable? So, and I'll throw it out to you as a plaintiff's attorney here. Not that you are a plaintiff's attorney, but
sometimes, but rarely, yeah.
Usually you don't sue fire departments, neither do I. But so you have a fire department shows up, elevator one is stalled, they shut down elevator one. Elevator two, they need to open the hoistway door for elevator two. They shut down elevator two and they open the hoistway door. The desk clerk tells the people, don't use elevator one, elevator two is still operational, because to the best of that person's knowledge, it was just elevator one that stalled. So the fire department's up on the second or third floor or whatever. So the desk clerk doesn't know. And the firefighters are now working, getting the people out of elevator one, but the hoistway door to elevator two, for some reason, is still open, and in walks our plaintiff, and she, I don't know how far she fell. It doesn't sound like she fell that far, but once that hoistway door is open, and then even if they had closed the door, it could have been a couple of feet below, it could have ended up a couple of feet below. I think that's kind of a stretch there. So again, we don't know all the details, but they're alleging, that there was a problem. Now, the question I got on LinkedIn was pretty good. And, to me, it's really about the fact pattern. It's not so much the question had asked me, is there any precedence for holding a fire department liable? And I said, precedence isn't really an issue here. Yeah. It's the facts. And if the fire department had opened the hoistway door, or the fire department had caused the elevator car to be lower than what it should have been, then the fire department created the hazard.
Right.
And factually, they now have a duty of care if someone could be injured because they did it. If the fire department's just on scene and there just happens to coincidentally be another malfunction of another elevator, they're not responsible for that. They didn't cause that, and they don't have a duty to, make safe something that is existing in that building. So interesting issue. Again, here we go speculating.
And there's no way to know. Look, and you could change the facts even more. Now say it's an emergency. Somebody's having a medical emergency in that other elevator, so they can't focus on the one she tripped in. So they're dealing with an emergency. I mean, you could change the facts so many ways. But look, this is a basic negligence case, right? They probably had a duty to somebody, though maybe not, right? Public doctrine, duty doctrine, who knows? But if
right, that's where the precedents could come in, because very often in a case like this, what the defense, the city's or the fire department's defense is going to be is like, even if we were negligent, number one, even if we had a duty,
right?
Number two, even if we breached that duty and were negligent, okay, we do not have liability because we've got statutory immunity, we've got sovereign immunity, we have some sort of immunity that is associated with carrying out a public function or whatever it may be. So there could be other precedential reasons why we don't even get to the merits of the case.
We just don't know enough about it, but it's a nice transition to our next case. So if everyone's in here confused, what the heck did I just learn? You learn nothing. Don't create dangerous situations when it's avoidable. But now we have an issue, right? Where we have, let's go to Sacramento, because it transitions so nicely. And I think what happened is the Sacramento Fire Department is battling a junkyard fire, and they got a bulldozer or forklift or something. I think it's a bulldozer to help clear the way to get to the fire. And they destroyed this individual's $68,000 vehicle. The allegation is, listen, you didn't have to push that vehicle out of the way with a bulldozer or forklift, whatever it was. You didn't have to destroy the vehicle just to get to this other fire. And here, now this raises some really interesting questions, and we don't have any more of the facts. So let me present one possible factual scenario. I'm making this up. Let's assume they could have gone straight, and maybe it would have taken a little bit longer, but they could have gone straight and then taken a right and got to the same place without having to push anything out of the way. Or they went, wanted to go right to it the shortest way possible, so they knocked a vehicle out of the way. If they had another way, right, because that's what they're saying, there was another way, you didn't have to destroy my vehicle. If there was another way and time was not an issue, right, something's on fire, it's burnt, and by the way, it's in a junkyard, right? There's nothing. Now, I don't know why this person's $68,000 vehicle was parked in front of the junkyard, but nonetheless, right? And that could be a defense too. We assumed it was junk, maybe not. I'm making that up. But nonetheless, there was really no emergency, maybe air quality or something. There's really no emergency when things are burning in a junkyard. Let's be fair.
Well, I don't know. I mean, it depends on how big the junkyard is and whether the fire was extending. And the fact that there was a bulldozer there leads me to conclude that, if I'm assuming it's a fire department bulldozer or one that the fire department had brought in, but you start using bulldozers you don't
pretty
use
aggressive.
a bulldozer at a single vehicle fire, right?
Yeah, right.
You don't. What you're talking about bulldozers is where you're concerned about, a major interface fire, and you're trying to, clear a fire break.
Yeah.
So this may have been a pretty significant incident. I don't know.
And maybe, and that's the unfortunate part. We just don't have the facts. But I think the simple thing is, listen, if they could have exercised judgment, which I'm not saying they had to, and taken an obviously different route, and they knew the route was there and time wasn't an issue, right? I'm throwing in a bunch of factors that would relieve the fire department of duty. On the other hand, I'm also assuming this person was parked somewhere that they should have been. Maybe they weren't. Right?
They were the couple. It was a husband and wife, and they had parked the car. They were both long distance truck drivers, and so this was a parking area where the truck drivers would park their cars and then pick up their their Peterbilt or whatever,
right.
and go. So it was parked there for a long period of time. So it wasn't a question that they didn't asked them to come move the car. It was a question that they were out of town.
But they were in a legal space, right?
Yeah.
So presumably, if it's a designated parking space, that parking space is not blocking an entrance to anything. So the question would be, do they really have to do that? Look, if they had to move that vehicle, no problem, right? And the insurance company will probably cover it anyway, or maybe the junkyard should, who knows, right? But if there was no other way to get there, probably no liability. If they could have exercised reasoned judgment and they could have just gone a different way, maybe. Either way, it's going to be an insurance claim anyway.
It's going to be an insurance claim. And I think that there's probably, this is the type of incident that is going to be, whether it's a public duty doctrine or whether it's going to go to sovereign immunity. I think there's going to be some sort of protection for the fire department, even if they were negligent. Now, if they went beyond negligence, then, the immunity isn't going to help you. But if they were just negligent.
I'm assuming they didn't intentionally try to run over a car and destroy a car just because they could. I
had a case. I had a case early in my career where it was a snowplow case, but guy had a classic car. I forget if it was a Caprice. It was a totally rebuilt mint antique car. And we had kind of a snowstorm that ended up starting earlier than predicted, and he parked it in a public parking lot at a recreational area. And then it snowed all night and snowed the next day, and quite a bit of snow. And whoever had a snowplow just intentionally destroyed this guy's car. All four sides of it were caved in. I mean,
Jesus.
And it wasn't insured because it was, it was an antique and it wasn't properly insured. And so, but we couldn't prove that it was a city plow. We're convinced that it was a city plow, but the police mishandled the paint chips that we gave them.
Oops.
Yeah. It was a mess.
Well, let's assume that's not this one.
Yeah.
So, could be liability. Now, just to continue the theme of, I don't understand any of this week's cases. They're just so sporadic. Let's go to Buffalo, New York.
Boy.
So you take this out. I'll just.
Have you followed this case? I got to ask you, because you and I haven't talked about this case, but have you been following this?
Only generically, not as much as maybe you have. But you take a very interesting spin. So here, look, the basic facts are it's St. Patrick's Day. The Buffalo firefighters are in uniform, right? Which you'll highlight as an important fact. There's an altercation between some of the Buffalo firefighters, and a serious one because the plaintiff, a firefighter, is seriously injured. And so he and his wife, you're thinking, why is his wife suing? His wife sues for something that's called loss of consortium, right? Because my husband's tied up, he can't do things around the house or anything like that, including sexual activities, which is part of loss consortium. That he, I get to recover as the wife because the husband's not around. In any event, the big issue I think that you take out of this, and I'm interested to see where you go, is mostly because of the interview process. So I'm going to turn it over to you because, right, we know they're in uniform. Nobody cooperated. It's, the blue wall, so to speak, right? Except on the fire side, but, and nobody's cooperating. So I'm going to turn it back over to you because we have a very interesting interview scenario.
Yeah, we do. And I just delivered the training on this last week. We'll be doing another one, I think, in September or so, or August. But it gets to the Garrity rule. And it has to do with when does a firefighter have a right to remain silent and when does a firefighter have to answer the employer's legitimate questions. And the Supreme Court has dealt with it because there's a Fifth Amendment issue, your right to remain silent, that can be compromised. So what the court has said in the Garrity case was called Garrity versus New Jersey.
Very, very famous, so everybody knows. Very important case.
It's an important one, and it's not well understood by most lawyers either, and myself included. I put myself in that. I would say, other than the last 10 to 15 years, I haven't fully grasped it. But very, very important decision. But what the Supreme Court has said is that if your employer asks you work-related questions, and they compel you under threat of termination to answer questions, you have to answer the questions. Now, it has to be work related, and it's actually, I'm using the term work related, but the actual language is it must be specifically, directly, and narrowly related to the performance of your official duties.
And that's the key, official duties, because they're at a parade, at a bar, after the parade, but in uniform. So question is, does that make it an official duty? And I'm betting they have an off-duty conduct policy in the city of Buffalo.
Yeah, but even then, that's not off-duty conduct. I mean, you can still discipline, and this is the thing, but let me kind of go through the issues here, okay? If your employer properly orders you to answer questions under threat of termination, and you answer the questions, your answers cannot be used against you in a criminal case, but you have to answer the questions. Okay. Now, if your employer orders you to answer questions that are not work related and you answer the questions, no immunity. So now your Fifth Amendment right to remain silent kicks in.
Yeah.
Okay. So the question here is going to be whether or not these firefighters were engaged in official activities of the fire department, which arguably I'm assuming that they had marched in the St. Patrick's Day parade. I'm assuming.
But I'm also assuming they didn't get paid to do so.
I'm also assuming that, and I'm certainly assuming that they were not being paid while they were in the bar afterwards.
Hope not.
Okay. So having marched in my share of St. Patrick's Day parades, okay, but so they probably didn't get paid. They probably were drinking. I'm assuming they were drinking. So now we've got a question: can the employer compel? And it's really important here because if the employer compels them and they refuse and they should have answered, they can be terminated. So that's sort of, there's a little bit of there's a lot at stake here. You can lose your job or you could be charged criminally.
And they're competing issues. I mean, that's the problem. How does a firefighter know, look, Weingarten, let's get a rep, near me to maybe advise me on some rights before I say anything, right? Enter Weingarten, but
I'm not sure you want your union rep helping you with this one. Right? I'm not sure you even want most attorneys helping you with this one. You want somebody who understands Garrity, and that's the problem. That's one of the reasons why I'm delivering the training, is because there's so much misinformation out there that we're seeing people lose their jobs because they're getting bad advice because the people who are giving them advice don't know the law. Right. And you've got to know the law. And here's the other part of it. I use the acronym SDN, specifically, directly, and narrowly. So SDN, specifically, directly, and narrowly relating to the performance of your official duties. That has to be the analysis here. And most of the cases in this area are police cases. And the cases are all over the board. I mean, they're all over the board. It's like, you got to be kidding me. There's a case out of New York.
Judges don't understand it any better.
I'll give you, there was a sheriff's office. I don't remember what county it was, but county sheriff. And the county sheriff, this particular deputy, is working for he's agreed to go undercover for the FBI. Okay, so now he's wearing a wire on duty for the FBI. Okay, and now his boss calls him in and orders him to answer questions about whether or not you're working for the FBI. And he says, "I'm not answering your questions." And he gets fired. And now he sues to get his job back. Okay. And the question is, was that SDN? The court said it was not specifically, directly, and narrowly relating. He's on duty. He's wearing a wire at work. How can that not be specifically, directly, and narrowly? So what I think we have is judges that are trying to find substantial justice without regard to the facts.
Right. They're trying to make, I would say they're trying to make the facts dictate the law, not the law dictate the facts.
And so the bottom line is this is a very, very difficult area. And I think if you have a good attorney on the firefighter side and you have a fair attorney on the city side, reasonable minds can differ. If you have pricks on both sides, you're going to have a problem. You have obliviousness on both sides, you're going to have a problem. But when you have reasonable minds on both sides, you can kind of reach a compromise and find the right. So I think the more people that we have out there that understand Garrity, the better off the fire service is going to be. We're way behind law enforcement. Law enforcement deals with this all the time because their police officers are getting themselves. It's the same gene pool that we hire from.
Right.
You know, so they get themselves in trouble and they find themselves in Garrity situations. Probably for every one we have, they have 100.
But
So,
I think, you know, trying to come across with a takeaway, right? If people are like, okay, wait a minute, we get it. It's confusing. What do I do when I'm being asked questions that may or may not been in the performance of my official duties, which, by the way, is very tough if you're a higher level person, right?
Mhm.
Because then you're not so defined as on duty, off duty, the same problem that this case presents. You're in uniform, but you're drinking, you're out. So I could see this, okay, you're at FDIC, you just spoke, you're wearing your Class A's, right? We can come up with a lot of reasons. So the takeaway I would say is you don't have to refuse to answer the question, but you can say, I'm not answering it now, and I need to look at my rights, right? I don't refuse, say, I'm not answering, but
Right.
let me determine whether I need to answer.
well, it's really there's two prongs here. One is, are the city investigators trained? Do they know what they're doing? And are they compelling you under threat of termination? What I tell my union reps when I train the union reps and my clients that are the unions, there's two questions. If you're on the firefighter side, there's two questions that you have to ask. And number one, is my guy being compelled under threat of termination to answer questions? And if you don't get a yes, then you don't have to answer. Okay. If you get a yes to that first one, the second question is, do we have your assurance that his or her answers will not be used against him in a criminal case? Okay. You need a yes to both of those. Okay. You need a yes.
Except that think about that second one. So I interview you from the employer side. I interview Curt as a firefighter. I say, listen, you have to answer. You could be disciplined. But I'm telling you, because this is on duty, they can't use it against you. Well, says you, not says the police or the courts.
Yeah, it doesn't matter. It doesn't matter. Yeah, that's a.
Well, wait a minute,
I'll send you the cases. I'll send you the cases. Yeah.
Because the employer can't necessarily withhold the information if the police legally get the admission, can they?
Yes, Map v. Ohio. Map v. Ohio. The exclusionary rule will apply to any of the answers.
If they were properly within the scope of Garrity.
Exactly.
If the employer was correct.
Correct.
But that's my point. The employer may not be correct, right?
Well,
and
correct in what regard?
Gave you assurances that your Fifth Amendment rights are protected.
Right.
And then they're wrong.
Well, it's got to be SDN. It's got to be specifically, directly, and narrowly relating. So, again, you know, we're talking about really a 4-hour class here. We're trying to do it in 5 minutes, but a lot of moving parts. But also another concern here is union reps, because this is not a good situation for union reps. And union reps should bring in an attorney. And I know union reps don't like to bring in an attorney, but many times
this is the time.
This is a situation. It's a complex area, and not even every attorney is going to be up to this because they don't have the knowledge, you know, of Garrity to the degree that you need it. So you need to have an attorney available to you who can advise you and maybe even come to the interview to help make these difficult decisions. You know, because you know, on one side you've got the potential for somebody to lose their job. On the other side, you've got the possibility of a crime and being convicted of a crime. You know, there's a lot at stake.
Sure. Okay, so I'm gonna pitch your class for you though, because you got a class coming up, and it seems to me that
we just had it last week.
You just had it. Okay,
just had it last week. We got another one probably September or so, but we do cover it. I mean, we're going to talk. Whenever we talk discipline, we talk Garrity, but we don't talk 4 hours of Garrity. We talk about 45 minutes of Garrity in the regular discipline class.
I'll put it this way: it's one you don't want to get wrong.
You do not want to get this one wrong. No.
Okay, so now let's go to Texas. This is another short one, nothing to focus on unlike the FDNY and stuff. But we have a deputy chief who claims that he was terminated, but he claims that the reason he was terminated was as a result of his whistleblowing activities, that he raised concerns that firefighters were paying each other under the table to trade shifts, which was interesting because I don't know if it's improper at their level. I mean, I don't think that's a violation of state law necessarily. If you want to compensate somebody to take your shift, I don't, at least New York law and other laws I'm thinking of, I can't think what's wrong with it, but nonetheless, he reported it. And then he's now being terminated. The question obviously will be whether the termination had to do anything with his reports. And if it did, whether the reports, if they were about a legal activity, right, or in any way were even protected by whistleblower protections. There is a long line of cases that talks about if you report something that's not illegal, there's no protection about it. You have to be reporting protected activity, improper activity, because if you say that something's legal, why would they retaliate against you? There's no reason to retaliate. There's no reason for anyone to retaliate. Oh, Curt, you wore a blue shirt today. I'm going to tell on you. Who cares? There's no reason to retaliate. So I think the first step is he's got to prove that what he reported was violation of policy, violation of law, improper, whatever. And if he makes that burden, he's still got to come forward and show he was, he made the claim, they knew the claim, and that his termination was directly related to having been a whistleblower.
I get asked a lot about the FLSA, the Fair Labor Standards, which allows substitutions. In private industry, substitutions are not allowed. They are allowed in the public sector. And there is no provision in the FLSA or any of the Department of Labor's regulations that prohibits paying for substitutions. Okay, so on the federal side but the IRS, there is an IRS issue here, and it has to be properly reported because the person who is paying, is paying someone. There's 1099 issues. There's other IRS type issues. That could involve civil infractions. It could involve criminal activity as well, unpaid taxes and that type of thing. So there's possibility of some criminal offense, not under the FLSA, but under the IRS. The bigger concern is whether or not there's any ethical violations under the state ethics code or the local ethics ordinances, and then something in the city charter. About no-show employees and different things. So there's a number of different ways that this can be illegal, but I'd say the biggest concern is going to be state and local law. If there's something that runs afoul of state and local ethics laws, you've got a problem. And I'm sure I can guarantee you the IRS wants to see documentation of the transfer of money on this account.
And look, we could, this is one of those things, again, we could make up scenarios, the pay to play, pay to trade scenarios. I'm just not going to go there. Obviously, we're not going to go there.
This case is out there in, I believe it was Cleveland, where a bunch of firefighters ended up being charged criminally, and they were convicted. I believe they all pled guilty to paying money or receiving money for substituting. And again, state by state, you got to look at the state law, and then even the local ordinances and ethics regulations can create a problem.
And then the employer is going to have to come forward with, listen, we had a totally unrelated, 100% unrelated reason for getting rid of them. And that's going to be their burden. And they could provide performance evaluations, warnings. They could provide a lot of things. What they can't say is, well, because you reported it, everybody hates you now. And so nobody wants to report you. So we're going to fire you because no one likes you anymore. Other than that, but okay. So, and then our last one.
I was just going to say real quick, just on that last one, I did a vlog with Deputy Chief Diane Hendry, a quick blowout. It was about an hour actually we spent, but it was just sort of like giving her perspective on what she went through in terms of her, she was retaliated against her according to her lawsuit, and what the way that she described it, she was retaliated against after coming to the defense of a female recruit. I'm not going to get into the facts of it. You can listen to the recording. I would encourage you to listen to the recording of it. Really, really kind of a sad thing. I think it was sad for everybody. I don't think there was any winners here. She ended up with a $2.6 million settlement, which people may say, oh, that's great. But, I don't know, where do you go after she's been forced out of that fire department.
Right.
I'm sure it's going to be difficult for her to get another chief's job. I hope she does in fact get a chief's job somewhere else. But that's one of the risks or the challenges of filing a lawsuit, is that, potential employer is going to look at this and say, oh, do I really want to, bring on board someone who's got a propensity to file suits? And,
Except she's right. Except here, she was right. I mean,
well, she was right, and I think that's when you win, it's a little bit easier to say, I filed the lawsuit. I didn't want to. I filed a lawsuit and I won. It's a little bit easier to say that you're not the kind of person that's just going to be bringing baggage with you into a new job. But I think there are people out there that legitimately are wrong, that don't necessarily get this kind of an outcome, and they've got that baggage. And I think that the time I recently had a conversation, I don't want to get into the details of it, with someone who brought a suit and then was upset that his name was being used in in the media. And you're the one that brought the suit. You brought the suit. You named all these other people that you claimed did something wrong, and then you're upset that your name is out there, and then it's making it hard for you to get a job. Well, I'm sorry. I have a lot more sympathy for the people who are named in the suit, that they aren't the ones that filed the suit.
Right, witnesses. But
people
don't understand. Let's kind of end with this, though, because it's a good point. People do not understand what it's like to be a plaintiff. Forget defendant. Defendant's just as bad, but to be a plaintiff in a suit, especially if it involves like a medical condition or a mental condition. Every one of your health records gets opened up because it's relevant. Your social media is getting looked at. Your history, your disciplinary history, your friends, depending on what the issue is. Especially if you're claiming mental damages, everything that could affect, what counseling did you go to? What else could have led to that? I mean, you are blowing up your life. So, my 2 cents, and I'm not exaggerating, every single week, I get a call about harassment or discrimination to sue a fire department or an ambulance. Now, out of 27 years, I've only accepted one case because I don't sue fire departments, right? I accepted one case and we won. But I got to tell you, what people go through is horrible, whether they're right or wrong. That I hope you have a lawyer who says, before we go down this road, let me explain the decimation to your privacy and to your life that all becomes public record that will never go away. So before somebody goes down, oh yeah, she just sued. Wait a minute. People who sue are decimating their lives to go through it. Nobody should want to be a plaintiff or a defendant, right? And what we do as lawyers to the people on the other side, plaintiffs or defendants, is brutal, because it's not pretty, and it's not private, and it's public record forever. So I sympathize with everybody who's part of a lawsuit, but to simply say, oh yeah, they sued and no big deal, they sued. Wait a minute, if they had the lawyer who told them what they're about to go through, and I have only 2 words for this, Nicole Mittendorf, right? She sues, wins, and then takes her life. This is horrible stuff, going through any of this. So it's bad for everybody, but nobody should think, oh yeah, she just went through it, no big deal. It's a big deal to go through this, win or lose.
All right. Excuse me. Well, that's going to wrap it up for another edition of Fire Law, and we'll see you next week. I'll be back home, and looking forward to getting through this week. We'll see how many cases I'm able to cover. I don't know. Hopefully, we'll get through the two days of classes and 3 days of skiing, 3 or 4 days of skiing.
Yeah, and just one advice to you in front of our viewers here: if a blonde famous actress happens to be skiing down, 1, don't touch her, and 2, just avoid her. Whether she accidentally runs into you or thought she was harassing you, I don't know, or you were harassing her, we don't know what the truth is yet. Just be careful.
I'm gonna do my best to get over to the courthouse, at least to get in there for a couple of minutes, but we'll see. We'll see how that goes. So, all right. And that'll do it for another edition of Fire Law